as a European citizens, I really hope that EU institutions will soon match words, the very ambitious and great words that we find in the treaty on the European Union will soon match words with deeds. Thank you for your attention.
Bene, grazie mille. Allora vedete che effettivamente ci sono un po' di sfumature diverse, perché Stutzman diceva che il principio di sovranità sulle risorse naturali implicava che gli accordi devono essere conclusi nell'interesse o in consultazione con la popolazione locale. Invece il professor Milano ci ha detto che questo non è un no ma è un ne, cioè è nell'interesse e anche requisito che quindi deve essere presente in modo congiunto in consultazione con i rappresentanti della popolazione locale, quindi bisogna immaginare il fronte polisario come rappresentante legittimo di questo popolo, no? Cosa che non è avvenuta. E anche la questione dell'interesse è tutt'altro che chiara, perché non ci sono in realtà meccanismi negli accordi per stabilire se questo interesse sia effettivamente o meno soddisfatto. Allora, su questi punti è naturalmente interessante considerare può essere il punto di vista non solo, diciamo così, del corpo diplomatico del Parlamento europeo, che prima ci è stato espresso da Stutzman, ma anche quello che è un punto di vista giuridico da parte del Parlamento stesso. Ah, ecco, non lo vedevo e quindi continuavo a parlare perché non lo vedevo più, prima era lì, poi era scomparso. Quindi abbiamo chiamato Riccardo Passos. Riccardo Passos occupa una posizione assolutamente eminente dentro il Parlamento giuridico, dentro il Parlamento europeo, perché è il direttore del Legal Service, del servizio giuridico, e quindi meglio di lui non ci può essere nessuno. I think you are going to speak in English maybe, or in okay, in English. Okay, so you have the floor.
Buongiorno a tutti, siamo tutti studenti. Do you hear well? Yeah? Well, first of all, I wanted to thank you for the invitation. I'm very pleased to be here. Very pleased to be with the students, because normally, you know, with the age, we go to the conferences where you don't have students so often. So I hope you will enjoy this day's seminar. Let me first of all introduce myself. I'm, as you said, working for the European Parliament. I must say I'm very proud to work for the European Parliament. I'm very happy to be in the European Parliament. And I once was in the committee for selection young people, and one of the candidates said, you know, the Parliament is like a street. You have everybody, not all the opinions. And that is the reality. It is democracy on a daily basis. And so I have a lot of respect from what Eric Hagen said a while ago. I appreciate what you do and what your passion, and I respect that 100%. And I also noted that you had contacts with the members of the European Parliament, and I'm also glad that you did that, because they have to be informed, not only by you, but also all other people who are interested in causes, and then they decide, they vote, and you have to respect that. Maybe you don't like, maybe it's frustrating, but that's democracy. The only thing that we want is that the members of Parliament are well informed, but then you have to accept that they vote freely. That's the rule of law. I also wanted to say that I will be speaking here today as an official. I don't have the same, I'm working for the European Parliament. I'm not speaking on my own, I'm not speaking on behalf of the European Parliament, but I'm an official of the European Parliament, so maybe I will be influenced by that somehow. One final word in the introduction about the legal service. The institutions, Commission, Council, Parliament, External Action Service, all have legal services. The legal services have a specific task, and in the Court of Justice has already recognized that in a case which was brought by an Italian, by the way, who was a former member of the European Parliament, Mr. Turco, and the court said that the legal service have to give legal opinions which are frank, objective and comprehensive. This is our obligation. So when we are asked by the committees or by the Conference of Presidents in the Parliament or by the Bureau of the Parliament of the President, we always follow that. We give in independence opinions which are frank, objective and comprehensive. I'll come later to that. Now, concerning the, I think I distributed to you more or less the plan. I don't know how much time do you give me. So I will follow more or less what I have distributed in the plan. That means first the position of the European Union concerning the status of Western Sahara, then the Fisheries Partnership Agreement, with which I have been speaking already for some time. Concerning the Western Sahara, I think that the European Parliament has acted through two approaches. One approach, more general and indeed more political, through resolutions concerning the situation in Western Sahara, notably relating to the human rights issues. I think Alexander also already mentioned that. Those are resolutions which are basically political, prepared by the political groups, and the committees are not involved, and nor is the legal service involved. The second approach is through international agreements, which are concluded by the Union. On those concerning Morocco, we gave 4 legal opinions. As you know, the legal opinions in principle are confidential, so I will not quote all the legal opinions, but they have been distributed. So they are almost public documents today, but I will at least raise some of the substantial parts of the reasoning of these legal opinions. I will focus on this only. So I'm very sorry to tell you that I will not speak on the political aspects of this conflict. It is not my job. It's not my. I will speak to you as a legal expert, and I can understand if you agree with me or not. That's part of life. I mean, we are used to that, and those who work for the legal services go very often to the court, and in the court there is always one who wins and one who loses. That's the way it is. Now, concerning the responsibilities of Morocco in the position, concerning the status of Western Sahara, I think it's true that at least the Union accepted 2 things. One is that the Western Sahara is a non-self-governing territory within the meaning of Article 73. And according to international law, this means, and to the General Assembly resolutions, this means that there are 3 possibilities from this situation. The emergence of a sovereign independent state, or a free association with an independent state, or integration with an independent state. But one thing is clear, and that is it was in the resolution 2229, that the administrating powers have to determine at the earliest possible date the procedures for the holding of a referendum under the United Nations auspices, with a view to enabling the indigenous population to exercise freely its right of self-determination. Concerning the Kingdom of Morocco, and that's the second element that also the Union has acknowledged, the Union has considered that Morocco was exercising the de facto control over the territory of Western Sahara, because it has assumed itself the responsibilities for the administration of that territory. Now, we know that this description does not correspond to the views expressed by Morocco, and I'm grateful to the Ambassador Correll, and he mentioned the speech of the King on the 6th of November 2014, just a month ago, on the 39th anniversary of the Green March, where he clearly illustrated that the Morocco does not see its role as an administrative power, nor Western Sahara as a non-self-governing territory. He was very clear when he said, the King, that Morocco, and I quote, is in its Sahara and never was an occupying power or administrative power. In fact, it exercises its sovereignty over its territory. And yet, if we read that the last report of the Secretary General of the United Nations, which was mentioned by Professor Milano of the 10th of April 2014, he says also very, very clearly that in its recommendations at the end of the document, he says two sentences which I think are worth mentioning. One, that it's paragraph 93, in the light of the presence of Western Sahara on the list of non-self-governing territories, the efforts of the United Nations through the work of my personal envoy, Special Representative in MINURSO, will remain highly relevant until its final status is established. And he also wrote, in the light of increased interest in the natural resources of Western Sahara, it is timely to call upon all relevant actors to recognize the principle that the interests of the inhabitants of these territories are paramount in accordance with Article 73. So you have here the two descriptions which do not respond to each other and which make things, of course, more difficult and complex. Now, the second part of this first part, which is still about the position of the Union concerning the status of Western Sahara, on the responsibilities of Morocco concerning the exploration and exploitation of natural resources. I think, and I follow from what I've heard already this morning, that two approaches are possible on this question. One approach, which was defended by some, also this morning, is that the Western Sahara people has a right recognized by the United Nations to its self-determination, and that Morocco has violated this right through armed force invasion of the territory in December 75. In those circumstances, Morocco has violated the parental norm of general international law, jus cogens, and according to this approach, the exploitation of Western Sahara natural resources by Morocco is, as such, a violation of jus cogens and therefore illegal. This is in the doctrine. You have several scholars who defended this thesis, and I think also, to a certain extent, Professor Milano just a while ago. But there is another approach which is to acknowledge that the status of Western Sahara is a non-self-governing territory, and that Morocco is the de facto assuming responsibilities for the administration of this territory, and shall respect the principles enshrined in Article 7.3, but that the question is whether it is not possible to... Okay. And the question is then if it's not possible to make a distinction between economic activities that are detrimental to the people of these territories and those directed to benefit them. And this is the approach of the United Nations General Assembly in 1995, which acknowledges that the value of foreign economic investment undertaken in collaboration with the people of the non-self-governing territories and in accordance with their wishes in order to make a valid contribution of the socio-economic development of the territories. This is the approach which is on the basis of the reasoning of Ambassador Correll. I think he will develop that after me. And I entirely agree with him and with this reasoning, and that is, it's not a secret, it is developed in the legal opinions of the legal service of the European Parliament, And I want to congratulate you because your position has been followed, I think, for the Union. You may criticize whether it was fully followed or not, but at least it was the reasoning which was agreed in the European Union institutions as a starting point. Now we'll go further and we'll discuss the implementation, but at least the other approach which I mentioned before, which was to say use cogents, not possible to have agreements with Morocco when it concerns Western Sahara, was not taken into account. And I don't quote now the conclusion of Ambassador Correll because it was already quoted, but you will agree with me that the difficulty is of course to assert how to implement if we come to the Fisheries and Partnership Agreement concluded with Morocco and the protocols. Can we say that the European Union and these agreements were negotiated, concluded and implemented by Morocco in accordance with the wishes and interests of the people of Western Sahara? We know this is the issue, and it's very complex. Also, as was mentioned before, enormous difficulty to consult the people in that respect, and also the lack of progress in the United Nations mission MINURSO since 1991. We have spoken about MINURSO already, and I think that the institutions, and Alexander also mentioned, give full support of this mission of the United Nations, and we all know that this mission is still pending before the instances of the United Nations, and the question is, of course, whether what the Union can do or not. But one thing is certain is that all the institutions, including the Parliament, acknowledge that this is, first of all, a matter to be dealt with by the United Nations. Now I come to the second part concerning the Fisheries and Partnership Agreement with Morocco. First, the agreement of 2006. There was indeed a certain ambiguity that was mentioned, especially by Mr. Hagen. Since 1983, the European Union concluded several fisheries agreements with Morocco, in 83, in 88, in 95. But as far as the European Parliament is concerned, and curiously enough, the question concerning Western Sahara was never raised. Only in 2006, the Committee on Development, which had to give an opinion to the Fisheries Committee, asked the legal service if the proposed regulation, Council regulation, concluding the agreement with Morocco, that would allow Union vessels to fish in the waters of the Western Sahara was compatible with international law. At that time, it was not clear whether the European Union vessels were fishing in the waters of Western Sahara, because, and I don't want to repeat that, Article 2 of the agreement is ambiguous when it mentions the waters falling within the sovereignty or jurisdiction of the United Kingdom. And moreover, the fishing zones were indicated in a way that it was not clear covering also the Western Sahara. I skipped the details. And given this legal incertitude, the advice of the legal service to the political authorities was to seek clarification. That's the first thing we asked. Ask the Commission and the Council about the scope of the agreement and how the Moroccan authorities intended to implement the agreement and how they foresee the benefits that it brings to the Sahrawi people. It was eventually mentioned that in case Morocco disregarded manifestly its obligations stemming from international law, the question could be raised by the Commission in the Joint Committee, which is foreseen in Article 10 of the agreement. And the Union could eventually enter into bilateral consultations with a view to suspending the agreement in conformity with Article 15. I think it was raised before that there was a presumption in this legal service that the Parliament legal service was not prejudging how Morocco would implement the agreement. That was criticized. I can understand that criticism, but I don't agree. We could not know until an agreement is implemented, if it's implemented in a way that corresponds to the respect of international law or not. The states are personnes de bien. They are bound by international law. How can we judge that they will not respect international law? So I think our legal opinion was prudent. Ask and then decide. This is our task. It's not the legal service which takes the decisions, but we have to give advice. This was our advice in 2006. In the meantime, in 2008 and 2009, members of the European Parliament asked questions, specific questions to the Commission. And this was referred by Mr. Hagen. I think maybe thanks to you they asked those questions. I don't know. But then, after the answers which were given to these questions, it was clear to us that the Union was actually fishing there, and the Commission declared that. The Commissioner Federer Wallner confirmed that in the Foreign Affairs Committee meeting once, and also in written answers they acknowledged that the EU vessels were fishing there. And in the light of this new information, which was not available before, the legal service was a second time requested to give an opinion in July 2009 to the Committee on Development. And here we could not say, well, go and ask if they are actually fishing there. We know that they were fishing there. So we actually examined the implementation of the agreement, in particular the programming measures. And we noted that even if some actions target port towns situated in the territory of Western Sahara, such as Lyon, Dakhla and Boujdour, it was not demonstrated that the EU financial contribution was used for the benefit of the people of Western Sahara. It would be also the role of the Joint Committee to ensure that the agreement is implemented in accordance with the obligations stemming from international law concerning the rights of the Sahara people over their natural resources. And we said, in case of doubts, the Union could envisage the suspension of the agreement or refrain from allowing vessels to fish in the waters of Western Sahara by requesting fishing licenses only for fishing zones situated in the waters of Morocco. This was our advice. And then there was the rejection by the European Parliament of the second protocol in 2011. I have to tell you that before there was no Treaty of Lisbon, so Parliament was only consulted, which means that Parliament had very limited rights. But with the Treaty of Lisbon, which entered into force in 2009, we have to give consent to international agreements, so we can reject. And as you said, we rejected this. We only rejected 3 international agreements. That was SWIFT in the United States, that was ACTA, and this one. This was the second protocol, which was similar to the first protocol, signed in July 2011, concerning a 1-year extension of the initial protocol. Before voting against, the Parliament voted another motion, which was to request the opinion of the Court about the legality of this international agreement. You know that according to Article 218.11 of the Treaty of the Function of the European Union, the institutions and the member states can ask the Court of Justice to give an opinion on the compatibility with the treaties of an international agreement. And this was put to the plenary for vote, and the plenary decided not to request the legal opinion of the Court of Justice on the 29th of September 2011. And yet it was an interesting question. And then on the 14th of December 2011, Parliament rejected the second protocol. Rejection was motivated mainly by economic, environmental and political reasons. Thanks to Mr. Hagen, he spoke about the economic and the environmental issues, so I don't have to repeat, but I will focus on the political reasons about Western Sahara. It was clear during the debate that this was, many members showed concern about the compatibility of the protocol with international law, especially the Fisheries Committee rapporteur, Mr. Karl Haglund, who, and I quote, this is in his own report, he mentioned, he made a reference to the PowerPoint that you were mentioning before, and he said that after many requests from the Commission about benefits to the local population, Morocco responded on the 13th of December 2010 with a PowerPoint document on the outcome of some investment programs divided into 4 different regions. The south includes the Western Sahara as well as the territory. And he says, the document does not show whether the people of Western Sahara have benefited socio-economically from the agreement. Although the document claims that jobs are created in all areas, it is highly likely that the agreement mainly benefits Moroccan settlers transferred into occupied territory in violation of Article 49 of the Geneva Convention of 1949. Regrettably, the document does not support any EU conclusion on benefits for either the local population or for the Sahara people. And following this vote or rejection, what happened was that the Parliament did not want to finish there. They adopted another resolution on the very same day, telling the Commission, because it is the Commission that negotiates the international agreements, parliamentarians do not negotiate the international agreements. And I don't know if I have time to come back to your issue about the information of the Parliament, but what you said is not correct. I mean, the Parliament is very well informed about negotiations. They do it in camera. The Commission comes at least once a month to explain how the negotiations take place. And I believe that after the Treaty of Lisbon entering into force, Parliament cannot say that they are not well informed. I mean, they are informed, and if they are not well informed, they can reject the agreement. Now, on this very day, on the 14th of December, the Commission, the Parliament adopted another resolution putting conditions, so to say, inverted commas, for giving consent to a future protocol. So they didn't say, we don't want any protocol with Morocco. We want a protocol, but we want the Commission to include certain things. Now, you can say this is not sufficient, it is sufficient. Professor Milano was saying it is not sufficient, but that's the way the Parliament decided to act. And they said that concerning Western Sahara, they said that the protocol should fully respect international law and benefits all the local population groups affected, without mentioning, it is true, Western Sahara. In this context, the Parliament insisted on having effective oversight mechanisms to ensure that funds earmarked for development, and in particular for infrastructure improvements in the fisheries sector, are used properly. And then came the third protocol of December 2013, which was also mentioned already. I will not go into the details, but I will only tell you a few things. The third protocol was signed in November 2013, following Parliament's recommendations. The Parliament recommendation was the following, and I quote, when we gave consent to this third protocol, we said in the Parliament recalls that its rights to be kept punctually and fully informed about the application of the protocol and its results, and therefore insists once again that representatives of the European Parliament should have the opportunity to attend meetings of the Joint Committee provided for in Article 10 of the Fisheries Agreement as observers. Further, calls for Parliament to be provided with documentation on the guidelines, objectives and indicators concerning the chapter relating to support for the fisheries sector in Morocco, and all information necessary for the proper monitoring of the aspects included in Article 6 of the protocol. Now, if it is a little bit too early, maybe, to make a first evaluation of the implementation of this third protocol, because it only entered into force in July of this year, and the fishing activities started only in September of this year. But I think it is useful to mention that in this, that the Parliament insisted on having details on this Article 6 and having a more active role of the Joint Committee on which the Commission is present. So, as you know, the Joint Committee is supposed to implement the agreement. So it is for the Joint Committee to say if the human rights, fundamental rights are not respected, we cannot go along with the agreement. We have to suspend it. It is foreseen. It was, as was mentioned by Professor Milano, it was also emphasized that we wanted to have, in the very beginning of the protocol, a reference to human rights in Article 2. And this Article 6 of the protocol is rather interesting because this financial contribution, which is 14 million a year, is foreseen as support for the fisheries sector, only for the fisheries sector, not for other policies. But the Parliament wants to control how these 14 million a year are actually used by Morocco. That's why we managed, I think it was Parliament's efforts, to have details in Article 6 about the procedure in the protocol. Morocco has to inform the European Union on how this allocation is spent as soon as objectives, criteria and exploitation exploitation are approved by the Joint Committee. From the first year, Morocco shall draw a progress report on projects implemented and submit it to the Joint Committee. The report shall include information on any social and economic consequences, impact on employment, investment, together, and I emphasize that, together with their geographical distribution. This is paragraph 6 of Article 6. The specific financial contribution will be paid in installments on the basis of an approach where the analysis of the results of the implementation of the sectorial support and the needs are taken into account. And finally, a suspension clause is also foreseen at the initiative of one of the parties. It is in the Article 8. And once again, I repeat, the Parliament said we want to have one member of Parliament in the Joint Committee to control. Maybe it is not sufficient, it is maybe not the ideal world, but this is certainly, and I can finish with that, is certainly an improvement in this third protocol if we compare it with the protocol in 2006. Now, is it a glass which is half full, half empty? We mentioned this morning that maybe a certain pragmatism is needed, and after all, we have to acknowledge that there is a political dimension in all this exercise, and I will finish.
Thank you, Mr. Kaskas. In fact, we have 20 minutes left for Mr. Corell. Please, Mr. Corell, if you want to come to the desk. Mr. Corell è stato quello che ha scritto il famoso parere che è stato tante volte evocato questa mattina, richiesto dal Consiglio di Sicurezza perché erano iniziate delle attività esplorative nel Sahara Occidentale di parte privata, però appunto il Consiglio di Sicurezza, che era presente nel Sahara Occidentale, voleva sapere se queste attività esplorative, che avrebbero forse preluso a uno sfruttamento, erano compatibili con il diritto internazionale. E Mr. Corell ha scritto questo parere che viene spesso ricordato in queste questioni, per cui adesso appunto gli do la parola per dire il suo punto di vista. Grazie.
Grazie a lei. Io parlo un po' italiano, ma se è troppo difficile di spiegare queste questioni complicate in italiano. Therefore, I'm going to address you in English, which is, of course, my working language in the UN. When I look at you now, so many students here, it struck me that I might formulate my presentation somewhat differently than I had thought from the beginning. How many are lawyers, students among you here? No. Political science? How many? Yes. Very good. Excellent. No, I just wanted to know, because it's important that you understand, when I speak here now, as I said in my abstract, I'm speaking in my personal capacity. I'm retired from public service. I'm a senior citizen, and therefore I'm free to speak my mind as I do now. And also, I would tell you that on the 8th of December, 1962, I started working as a law clerk in a court in my country, 52 years ago. And when I look at you, I realize that I was maybe the same age as you are now. So I hope that what I will say now, among you, you will listen carefully, maybe carry with you some of the advice that I'm going to include in my presentation. I have 5 elements, and also I am speaking as a neutral. What do I mean by that? But this is something I was taught in the courts. For 10 years I served in the courts before I came to the Ministry of Justice for 13 years, and then I've served in the Foreign Office as ambassador and head of the legal department for 9 years. And then I came to the United Nations, where I was a chief legal officer in the organization for 10 years. 3 years with Boutros Ghali and 7 years with Kofi Annan. Also, when I talk about neutrality, I'm referring to the analysis that the then Secretary General Dag Hammarskjöld made of the role of an international civil servant. And this is what I say, or I will say as a quote from him. The international civil servant, if he knows himself to be free from personal influences in his actions and guided solely by the common aims and rules laid down for and by the organization he serves, and by recognized legal principles, then he has done his duty, and then he can face the criticism, which even so will be unavoidable. As I said, at the final last, this is a question of integrity. And if integrity in the sense of respect for law and respect for truth were to drive him into positions of conflict with this or that interest, then that conflict is a sign of his neutrality and not of his failure to observe neutrality. Then it is in line, not in conflict with his duties as an international civil servant. This has been a lodestar for me in my work as legal counsel of the organization for 10 years. I intend to address 5 elements here, but I refer also to the abstract that is circulated. I know there you have 3 important links to documents that I refer to. First, my legal opinion from 2002. Second, the Fisheries Agreement from 2006-2007, when I discovered that. Then the new Fisheries Agreement, the 3rd element. The 4th element is the King Mohammed VI's speech in the early November this year. And lastly, Cosmos, the oil drilling ship that you saw in a cargo showed a picture of it. Those are the 5 elements that I intend to address. Now, as far as my legal opinion is concerned, it was a question I was asked to respond to by the Security Council, and this is rather unusual that the Security Council would ask the Legal Council to give an opinion in such a very important matter. But so they did. And the question was whether oil prospecting contracts given to 2 companies, Kerr-McGee and Tina Alf, were legal under international law. I will not go into detail of my legal opinion because it's better that you read it yourself. The link is there, and the document
has an acronym S, like in Sicily, stroke 2002, stroke 161. It's a very short document containing 25 paragraphs. Now, I was asked to give a legal opinion whether these contracts were legal under international law. And then, of course, I had to analyze the situation in Western Sahara. And this was not an opinion given by the legal office. It was given by the legal counsel, myself. That is a person who gives the opinion. But surely you must understand that I'm working with a team. I had 180 people in my department, 6 different departments. One of them, by the way, the law of the sea, which we are actually looking at here. And I had a very good team to assist me in preparing this opinion. And when the opinion was delivered, I concluded, and there was a quote earlier made here, and often they only quote parts of my legal opinion, because it's very important to read the very last sentence in the legal opinion. What was said in the opinion was, towards the end here, that the foregoing legal principles established in the practice of states and the United Nations pertain to economic activities in non-self-governing territories in general, and mineral resource exploitation in particular. It must be recognized, however, that in the present case, the contracts for the reconnaissance and evaluation do not entail exploitation of the physical removal of the mineral resources, and no benefits have as of yet accrued. The conclusion is therefore that while the specific contracts which are subject of the Security Council request are not in themselves illegal, if further exploration or exploitation activities were to proceed in disregard of the interests and wishes of the people of Western Sahara, they would be in violation of the principles of international law applicable to mineral resources activities in non-self-governing territories. It's very important when you read the analysis in the legal opinion to understand that we had to look at the situation in Western Sahara, realizing that this was a non-self-governing territory. But as a matter of fact, there was no administering authority. Under the UN Charter, it is a sacred duty to be an administering authority. That duty rested with Spain. But Spain just gave that responsibility away. They tried to invest it in Morocco and Mauritania. They had no legal authority whatsoever to do that. So the agreement concluded by Spain with Morocco and Mauritania is simply not valid under the UN Charter in respect of the rights of the Western Sahara. So by relinquishing this sacred duty, Spain actually caused the situation that we are now experiencing in Western Sahara. And as you know, the United Nations has been involved for a long time here, and I will come back to the Security Council action. But my presentation here is much, much broader in the sense than Western Sahara, because it reflects some of the problems that we are facing in the world today. You are the young generation. You are the ones who are going to take over after us. What is the situation we are leaving behind for you to take over? Could we not have done better? I'm asking myself. The whole issue actually points to one very important actor here, namely the Security Council of the United Nations. This situation has been going on and on and on and on. And in a way, when I now look at it, because when I gave the legal opinion, it was almost 13 years ago, I delivered the legal opinion. So much has happened, and I've been looking at other things in the meantime, since I retired from public service in 2004. But when I now am getting familiar with the situation again, I'm really quite astounded that the situation is as it is. In a sense, to quote a friend of mine, it's a charade. It is a charade. Something has to be done here. And all the actors here, and in particular since we are discussing the European Union, the Union should know better how to deal with this situation. And I'll come back to this when I come to the agreements. But it's very important to understand that if you are to use the resources of a non-self-governing territory for the benefit of the people. This is the first condition. It has to be for the benefit of the people. And you have to be able to prove that. And you have to consult with them, the representatives or whoever it is, depending on the situation in the decolonization, as it were. And then you have to also realize that it has to be done either on behalf of or in consultation with representatives of the people. What do I mean by on behalf of that I drew from the resolutions by the General Assembly over the years? Well, this means that they have come so far in the decolonization process that they have a representative body that can decide to hand over and ask an administering power to deal with this matter and to sell for their benefit resources from the territory. And this is not the case in this particular case. Now, so far, my legal opinion, that has been quoted many times, but I was quite taken aback when I saw how the Commission the European Commission had construed it from the beginning. It was nothing of the sort what I had said. The last sentence is what counts. It has to be for the benefit and in accordance with the will of the people of Western Sahara. When we come to the second element, the Fisheries Agreement, I was invited to Pretoria because they wanted to discuss Western Sahara as an example of processes of decolonization. And when I then saw the Fisheries Agreement, I didn't believe my eyes. What is this? I mean, they are talking about Moroccan fisheries areas and so forth. And when I looked at the coordinates, and might I add that during my tenure as the legal advisor of the Foreign Office in Stockholm, I negotiated 3 delimitation agreements in the Baltic, the one with the Soviet Union, then the one with Poland, one with Finland. So I'm very familiar with delimitation in marine areas. In the UN, I had the oversight of the Division for Ocean Affairs and the Law of the Sea. So I've been dealing extensively with sea matters, and I can read charts. I'm actually a sailor. I was, for 12 months during my time I was a student, I signed on trips. So I sailed for 12 months in 4 summers. So when I looked at the charts and saw the coordinates, I realized that these coordinates are actually referring to the whole area until you come to the borderline of Mauritania. But there's not a mention in the agreement about the fact that Western Sahara is a non-self-governing territory, and that Morocco does not have jurisdiction in the true sense of that area. Not a whisper. So when I was invited to address this in Pretoria, I noted some elements here that I might share with you, namely the way in which it was, yes, here it is. It was described. Yes, the protocol here. Let me reiterate what I said in the context of Pretoria. The protocol to the agreement refers to Morocco's resources, Article 4. With respect to the financial contribution, the protocol says that subject to Article 6 of the protocol, the Moroccan authorities shall have full discretion regarding the use to these financial resources or contributions is put. The protocol also mentions the Moroccan fishing industry, Article 8. The annex mentions the Moroccan Atlantic Zone, Moroccan seamen, Moroccan ports, and in Appendix 4, the limits of Moroccan fishing zones are indicated, apart from some small-scale fishing between 34 degrees north and 35 degrees north off the coast of Morocco. The rest is indicated by the entire Atlantic, apart from a limited area, for tuna fishing, and south of 29th degree for demersal fishing and industrial pelagic fishing. What does south of 29 degrees means? A tiny area southwards to 27-28, which is the waters of Western Sahara where they commence, or all the waters southwards to where the waters of Mauritania meet at about 21 degrees. I mean, it is so obvious that this agreement concerns Western Sahara's waters, and there is not a whisper in the agreement about the fact that it concerns Western Sahara. Now, I come to the third element, the new Fisheries Agreement. I looked very carefully at that, and basically it's the same all over again. When I looked in particular at the annex, first of all, the agreement refers to the Moroccan fishing zone. No distinction made with respect to Western Sahara. And when I come to Appendix 4, the coordinates are indicated. Again, I meet the same. There are 6 areas here indicated, and 4 of them are exactly indicated the way in which I quoted a while ago. South of 30 degrees 40 minutes, south of 29 degrees, all of the Atlantic apart from an area delimited by an irrelevant area here, and then 6 industrial pelagic fishing south of the 29 degrees. Not a whisper whether it is only a small portion, a few kilometers south to where Sahara, Western Sahara starts, or whether it's all the coast down there. So if I met an agreement like this in a court of law, my indication would be that, is this something signed in bad faith? This is how a judge would look at something of the sort. Now we have the 4th element here, and also if you read my legal opinion, I have quoted the General Assembly extensively when they adopted resolutions on self-determination. And here you will find actually the General Assembly is warning those who administer territories that are subject to decolonization of plundering the resources of the people in those regions. Now we have the speech of the king, and let me quote from this speech. He starts by saying that this is a speech on the occasion of the 39th anniversary of the glorious Green March. The glorious Green March, where civilians from Morocco were sort of transferred into the area of Western Sahara. Is this a way of expressing a violation of the 4th Geneva Convention? Article 49, the 6th paragraph of the 4th Geneva Convention. The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. And then there are actually now in the Rome Statute provisions that say that this kind of behavior could amount to a war crime under modern law. And I say this since I had the honor of being Secretary General Kofi Annan's representative at the Rome Conference for the negotiation of the Treaty on the International Criminal Court back in 1998. It's very important to have this distinction clear. You're not allowed to transfer your population into an area that is occupied in this way. Now, the king goes on to talk about in our southern provinces. We recover them, the southern provinces. The nation's territorial integrity is talking about. And then he comes to a quote towards the end. Let me say this, to reaffirm Morocco's position on the matter. We say no to the attempt to change the nature of this regional conflict and to present it as a decolonization issue. Morocco is in its Sahara and never was an occupying power or an administrative power. In fact, it exercises its sovereignty over its territory. The question I ask myself, is this statement basis enough to renounce the Fisheries Agreement? This is very, very serious. And now I come to the Cosmos issue. The Cosmos is steaming northwest to start drilling off the coast to see whether there are oil resources there. In this agreement, I just note that the company says that they are acting in conformity with my legal opinion. They are not. It's obvious that this agreement is also in violation of the manner in which the resources of Western Sahara should be administered. And also I note that the agreement refers to Western Sahara as the southern provinces. Let me see now at the curriculum. Yeah, the southern provinces of the Kingdom of Morocco. Already signing an agreement of this nature, in my view, would violate the principles of corporate social responsibility and the rugged principles of protect, respect and remedy. To sign an agreement where the Western Sahara is referred to in this manner is simply not acceptable. Now, what are the conclusions here? Because I don't want to take up too much time here. There have been so many speeches in the morning. What I will do now is to refer you to the broader aspect, namely, who is ultimately responsible here? But certainly, we all have responsibilities. And I must say that as a European, as I said in Pretoria, I feel ashamed that the European Union has concluded an agreement of this nature with Morocco. I have friends in many countries, but I have no connections whatsoever to the Polisario or to Morocco here. And this is why I mentioned my neutrality here. That I'm speaking as a lawyer and a former judge. And I'm trying my best to analyze the situation here and find a way forward. And as a matter of fact, when I now got familiarized again with the situation in Western Sahara, I'm contemplating to taking steps in my capacity as the former legal counsel of the United Nations. But what it boils down to is really something that is extremely important. And this is recognized by the United Nations. On the 24th of September 2012, the General Assembly adopted a global resolution on the rule of law. This, in my view, is the only way ahead. If you ask me, looking in the rear mirror from my years in the courts, in the Justice Ministry, in the Foreign Office in the United Nations, and now 10 years after I left the UN, I've been working, for example, for 6 years for Kofi Annan in Kenya, when he was asked to deal with the situation there after the terrible violence after the elections in 2007. This has been an extremely important learning experience. And I can tell you, in particular the students, that you never cease to be students. So sometimes when I address students, I start by saying, fellow students, you learn all the time, and I have the privilege, again, of learning all the time. And when I look in the rear mirror now, and look at the conflicts in the world, anywhere you have a conflict, you ask yourself the question, why is there a conflict? And the answer is the same: no democracy, no rule of law. In 2008, I was asked to give advice to an organization called the Interaction Council of former heads of state and government. And all of a sudden,